Hello everyone, thank you for coming. Today we are going to be talking about TROs, preliminary injunctions, and declaratory judgments. If everyone has not done so already, please sign in and grab a packet of information and a cookie if you want. I'll just briefly introduce Mr. Brown. Mr. Brown is a partner at Quintarius, Prieto, Wood, and Boyer. My apologies for butchering the pronunciation already. He is a practicing litigator. He is a adjunct professor at John Marshall Law School teaching remedies. He's just started teaching moot court. He's going to summarize the topic today, and we'll focus primarily, however, on specific procedural issues for practice in Cook County. A couple of other more information just quickly before we start. We do have another seminar on February 22nd. The topic will be preparing 2011 income taxes. The presentation will be done by Larry Krupp, who is a certified CPA. The goal is to interpret and explain the latest version of the tax code. After we finish today, if you are interested, as I'm sure you all are, this is CLE. You are eligible for CLEs. We have forms that will be available for picking up at the end of this seminar. In addition, we also have evaluations. Please fill them out. We'd love to know what you think about the presentation today and any ideas you have for future presentations. And with that, I turn it over to Mr. Brown.
Well, thank you for the introduction. Good afternoon. I'm Jerry Brown, and our topic is preliminary injunctions, TROs, and declaratory judgments. One of the reasons that I gravitate toward this topic is very early in my career, I would notice that whenever my practice group would get preliminary injunction and litigation, we would usually see a collection of documents all served on us at once. You'd have the petition for a preliminary injunction, a petition for a TRO, a complaint for permanent injunctive relief, and more recently also a complaint for declaratory judgment. And early in my career, I was always curious, is this just overkill? Is there a strategic reason why all of these documents are being filed at the same time, or is there really legitimate reasons for doing all of this? And I really didn't spend a lot of time to get into that, but just simply focus on litigating the case. And then when I started teaching remedies at John Marshall, I actually invested the time to see what are the technical differences and try to offer my students a reasonable explanation as to why it really does matter that you file some or all of these, and what are the advantages and disadvantages of proceeding under one pleading as compared to the other. Typically you will see requests for either emergency or non-monetary relief in the form, as I said, of preliminary injunctions, TROs, and declaratory judgments. And as I mentioned, we'll address the question, why file all of them and what are the differences between them? The Illinois law that governs TROs and preliminary injunctions are sections 511, 102, and 103 of the Code of Civil Procedure, respectively. And under federal law, it's Federal Rule of Civil Procedure 65A and 65B, respectively. One of the core purposes of the preliminary injunction and the TRO is to preserve the status quo. I've relied on the dictionary from Black's Law Dictionary to define the status quo as the last actual, peaceable, uncontested status preceding the pending controversy. The importance of preserving the status quo is, of course, if matters proceed unabated while you're litigating in court, the risk is that the matter becomes a moot controversy. The very harm you sought to avert, once it's happened and the court is powerless to do anything to reverse it, there's no point in trying to get a relief from a court to address the circumstances. There are different kinds of orders that fall under either TROs or preliminary injunctions. There are mandatory orders and prohibitory orders. As their titles suggest, a mandatory order is one that actually requires parties to perform certain specified acts. A prohibitory order is one that requires parties to refrain from performing certain acts. Mandatory orders are automatically stayed when an appeal is pending. A prohibitory order is not. The problem, however, with just relying on the application of law for a stay of a mandatory order is it's often unclear from the language of your order whether in fact is mandatory or prohibitory. So I advise my students, if you are appealing, try to include language that makes it clear that you are or believe that the order is stayed because of its mandatory language, or specifically request one. You'd hate to be in the shoes of someone who has simply assumed that the court is going to accept your view that this is a mandatory order, only later to find out that the court disagrees, and if your client has then relied on the belief that there is a stay and done so in error, they are later subject to a contempt proceeding. To think of an example, you may see orders worded such as, Mr. Jones is hereby enjoined from allowing further waste to the premises located at State and Lake. If he's enjoined from allowing further waste to the premises, does that order prohibit Jones from doing anything to the property, or does it affirmatively require him to take the steps necessary to prevent further waste to the premises? So one, if you're writing an order, try to be careful in how you write it if you really want it to be characterized clearly as a mandatory order or a prohibitory order. And actually later we're going to talk a bit about the problems of ambiguity in the writing of these orders and the consequences when seeking subsequent enforcement of the order. The elements for getting either a preliminary injunction or a TRO. While you see some variation when they're formally listed in cases, you typically see this listing. First, they're a clearly ascertainable right in need of protection, an irreparable harm, a lack of adequate remedy at law, a likelihood of success on the merits, the balancing of hardships between the respective parties, and courts will consider public policy if it is relevant to the matter being litigated. Let's discuss briefly each of these elements. In terms of there being a clearly ascertainable right in need of protection, it's important to keep in mind that just because something bad is about to happen to you or your client, that does not in and of itself mean that you have a basis for bringing a TRO petition or an injunction. For example, imagine your employer is about to be foreclosed. If the foreclosure goes through, you're going to lose your job. The mere fact that you're going to suffer the harm of losing your job does not give you, the court does not recognize that as an ascertainable right that would sustain a TRO or a preliminary injunction. Moreover, absent an ascertainable right, you then run into a question of, do you have standing? Is there a real controversy with respect to you? Someone else may have an interest in the controversy at hand, but unless you can demonstrate your own ascertainable right, you will not have the basis to proceed for an injunction or a TRO. An irreparable harm. Typically, that is, at the risk of oversimplifying, it means that money damages are not enough. That for whatever reason, an award of money damages will not cure the harm that you're bringing to the court's attention. The most successful form of irreparable harm that can be alleged is usually the violation of a fundamental constitutional right, even if it's a brief, the violation or interruption is brief in duration. For example, race discrimination, or a violation of your right to vote, or to exercise right to free speech, or to free exercise of religion. Even brief violations or interruptions of those rights, courts consistently recognize as an irreparable harm that will sustain, that can sustain a petition for a TRO or a preliminary injunction. There are examples, however, in which monetary interests can sustain a request for injunctive relief, particularly when the ability to calculate the magnitude of the monetary harm is elusive or simply not feasible, or the ability to actually collect on it is really not realistic. For example, if you're operating a brand new business or even an ongoing business and you're threatened with a pattern of conduct that threatens to shut down the business, given a choice between forcing a petitioner in those circumstances to suffer the closure of the business and then trying to calculate the totality of monetary harm from that point, the point of closure, to what would have been the lifespan of the business, as compared to giving or granting injunctive or TRO relief, the court will recognize a harm of that nature as one that is sufficiently irreparable to justify equitable relief. The lack of an adequate remedy at law. Again, typically we understand that to mean that money damages are not sufficient. There are other remedies at law that we often overlook when performing an analysis of equitable relief. Ejectment is a remedy at law. Mandamus and habeas corpus are understood as remedies that are also available. So when you run into a real challenge on the issue of whether there are other remedies at law, don't stop with money damages. There are particularly real estate disputes where if an ejectment really is a means for resolving a controversy, the court may refer a party to proceeding with an ejectment rather than granting a TRO or a preliminary injunction. Likelihood of success on the merits. What this means is that you've demonstrated to the court that your claim has genuine merit. It is not a determination as to a binding determination as to which side is right on the law. This is simply the court's determination that enough has been demonstrated to justify the court order that would preserve the status quo and enjoin the other party from proceeding further to in a way that would moot the controversy. The balancing of the hardships. In matters of equity, the court will evaluate what is the harm that would be suffered by the petitioner if relief is not granted, as compared to the harm to the respondent if the relief is granted. If the harm is disproportionate one way or the other, that will play a factor in the court's decision. And last, the courts will consider public policy if it's relevant to the disputed issue. If there is a clearly articulated public policy that strongly favors or disfavors the result being sought, courts will evaluate that. The courts balance each of these factors, so simply prevailing on one of them does not guarantee you a result in your favor. The differences between preliminary injunctions and TROs. Among the most important differences is that TROs can be issued on an ex parte basis. Preliminary injunctions cannot. So it raises the question, why would you find it necessary to proceed on an ex parte basis? There are circumstances where, for a variety of reasons, it may not be possible or feasible to get notice to the opposing party of your petition before the hearing. I urge my students that in today's modern world, where we have faxes, emails, BlackBerry, cell phones, etc., it's increasingly difficult to argue convincingly to a court that I just had no way of giving notice to the other side. There are circumstances where you can in fact make that argument, but be wary that courts will look at that with some skepticism and you do have to certify to the court in writing what efforts you made to give notice to the other side and why it's urgent, it's imperative that the court grant relief prior to the other side having an opportunity to be heard. One case that I've actually litigated where I was doubtful as to whether I had actually gotten notice to the other side. It was a family dispute over ownership of a restaurant and its property. My client was the owner, and he was afraid that his manager / family member was about to sell off all of the assets to someone else and just pocket the cash. So he wanted an injunction to stop his uncle from doing that. And we could not find a clear or a certain address for this person. So the best we had was, I think, his mother's address where he is believed to show up from time to time. We thought we had a cell number, so we used whatever addresses and communication means we could, and we certified to the court in an affidavit. We served him at this address. This is the only address we have. This is a cell number. We gave telephone notice. We actually did the service by both the U.S. mail and by courier, so we could satisfy the court that yes, we've done the very best we could to give notice to this person. Another reason for an ex parte proceeding can be, and the courts are even more skeptical of this, but it is a legitimate basis. If you can demonstrate to the court that if the other side is given notice, they will accelerate their conduct in light of the upcoming hearing so as to moot the controversy and therefore defeat the very purpose of the hearing for which you are seeking the court's assistance. A court is not likely to regard that allegation casually, but if those really are the circumstances you face, be prepared to argue them to the court, and that can be a legitimate basis for asking for ex parte relief. One of the disadvantages of a TRO is while it can be issued on an ex parte basis, its initial duration is limited. 10 days in state court and 14 days in federal court. They can be extended beyond their initial term with a showing of cause to the court. But with a TRO, you have to keep going back and extending its application for a good cause. For a preliminary injunction, you do not have a preset duration. So one advantage of getting a preliminary injunction instead of a TRO is once it's ordered, typically you will not have to keep going back every 2 to 3 weeks to have it re-extended on an additional showing of good cause. What you will typically see is once the TRO is issued, the court will order a hearing as soon as possible for the other side to have an opportunity to be heard, and if the court is persuaded, they may then issue a preliminary injunction after the TRO so that it can still preserve the status quo while setting aside time to adjudicate the underlying merits with respect to a claim for permanent injunctive relief. So again, the advantage of getting a TRO, if you cannot get timely notice to the other side, or if you fear that they're going to accelerate their conduct to moot the controversy, the TRO, it's the best way to proceed. If you can get notice to the other side, the advantage then is with the preliminary injunction. Often when you're filing these proceedings, you may not know in advance whether you're going to be able to get service on the other side or whether the circumstances are such that they're going to really try to moot the controversy by just accelerating their conduct. So by filing both, if you've not gotten service on the other side, you have the option of asking the court for a TRO, and alternatively, if you have gotten notice on the other side, you can then request a preliminary injunction and not be subject to the preset limitation in terms of its duration. And again, one other strong disadvantage with TROs, particularly on an ex parte basis, courts do strongly disfavor ex parte proceedings. If a court is not persuaded that this is such an urgent matter that it just cannot wait for the other side to at least be heard, I suspect the most likely result you'll get is we'll enter and continue this until for another 3 or 4 days so that the other side can be here and make an argument. A trial court has substantial discretion in deciding whether to grant or deny a preliminary injunction or a TRO, and the determination will not be disturbed on appeal absent an abuse of discretion, and there is no right to a jury trial for an injunction or a TRO. The issue of bond, it often isn't as a big focus of many equity hearings, and there can be a real consequence for failing to prepare for arguing the issue of bond. Under Illinois law, the court in its discretion may require the posting of a bond before entering a preliminary injunction or a TRO, and under federal law, the bond is actually required under Rule 65C. The purpose of the bond is to provide a source of relief to a party who, it turns out, is wrongfully enjoined by an improvidently entered TRO or preliminary injunction. And it makes sense. If the court orders you to either cease a pattern of conduct or to perform certain acts, and then you or your clients suffer demonstrable monetary harm because you complied with the order, it's only fair that there be some recourse for actually addressing the harm that your client suffered by having been wrongfully enjoined. It raises the question, however, what to do if you disagree with the amount of bond that the court has ordered. And it's not rare to see lots of effort put into the merits argument as to the TRO or the preliminary injunction, but then when it comes to the bond argument, you don't see nearly as much of an effort made in arguing, one, that there should be a bond and what that a bond amount should be. And the problem is, if you end up with an inadequate bond amount, what can you do? If you do not challenge that bond amount or get it adjusted by the court, and then, oh, sorry, I thought that was mine. If you end up at the end of the proceedings and it turns out that you were wrongfully enjoined and then you seek relief on the bond, you're limited by the bond amount, even if the harm you suffer is significantly greater than the amount in the bond. So what do you do if the court gives you an inadequate bond? You can seek rehearing on the question of the bond. You can appeal the question of the bond. As a practical matter, however, if you've not made your best case possible at the trial initial argument, the problem with appealing the bond question is your client may balk at financing an appeal of the bond. But I mean, just pulling some numbers out of the air, let's imagine your client wanted a $50,000 bond posted. The court orders a bond of $20,000. Is your client going to want to finance you filing an appeal, drafting in a brief, and a reply brief? And it's unlikely, you may not get oral argument, let's say you do, and then preparing and then performing an oral argument. If you get to a point where the expense of prosecuting the appeal dwarfs any conceivable benefit you would have, even by a positive result in appealing the bond amount, then just as a business matter, your client is unlikely to authorize you going ahead with the appeal. And also, just keep in mind the contingent nature of the relief you're seeking in the first place. It may turn out that the court rules at the end of the day that you were rightly enjoined, in which case the bond amount will turn out to have not been relevant in the first place. So unless you really have a very large discrepancy between the amount of bond protection you really need for your client's protection and what was actually ordered, the economics of prosecuting the appeal on the bond is almost certain not to be worth the effort. So again, in light of those financial realities of litigating the appeal, the best time to really make your strong argument as to what the bond amount should be is at the hearing, and also worth keeping in mind any argument that you did not make at the trial level, you will have waived on appeal anyway. So if you show up at appeal making all these great arguments that you never bothered to make at the trial level, you're likely to get the response as counsel, those arguments are waived. Yes?
Is the bond appeal, I know the TRO appeal in Illinois is accelerated. Is the bond appeal accelerated?
You can request to have it accelerated. I must say I have not run across much case authority that really maps out in much detail the process for doing that. Yes, you can ask for it. How likely you are to get it, again, that's at the court. If the court does not think that it's urgent that we decide the amount of the bond immediately, I think it's much harder to get that heard on an accelerated basis. Adverse rulings on preliminary injunctions or TROs, they are subject to interlocutory appeal. The basis for that under Illinois law is Illinois Supreme Court Rule 307A and D, and under federal law, 28 U.S.C. Section 1292. The notice requirements for preliminary injunctions and TROs. Under Illinois law, they are governed by Illinois Supreme Court Rule 11. It authorizes hand delivery, U.S. mail, commercial courier, facsimile. Email is not explicitly authorized as a means for service. Under federal law, that's governed by Federal Rule of Civil Procedure 5, and it authorizes hand delivery, U.S. mail, electronic means if the other party has consented, and any other means which the other party has consented in writing. So there's some flexibility. I've not run into too many cases where at the state level someone, for example, was given actual notice by an email and the other side came in, well, Your Honor, I did get the email, but that's not affirmatively authorized under the rule, so we should throw everything out. But you know, the rule is stated as is, so I would first try at all possible to execute under the service under the means that are clearly authorized. If failing those, in addition to those, I would use email to try to ensure that there has been actual notice of the proceedings. Federal TROs, they do anticipate oral notice of the proceedings. Other methods, they run the risk of technical noncompliance, but they may in fact be more effective in achieving the purpose of the notice provision. In addition to these rules, I would also check whatever local rules would apply in the jurisdiction where you're litigating to see if they provide additional guidance or requirements as regard to service of notices of TROs or preliminary injunctions. In setting forth the elements for equitable relief, we discussed some of the elements, and I want to provide a bit more detail in the discussion of the elements than what I provided earlier. With regard to an irreparable harm, a party cannot be adequately compensated in damages or when the damages cannot be measured with any certainty. As I said, violations of constitutional rights, however brief, usually qualify as an irreparable harm. They are not the only irreparable harm that is recognized by the court, but it is usually one of the most reliable in terms of getting the court to sustain an order. In terms of lack of adequate remedy at law, the traditional remedies at law, money damages. In addition to that, there's ejectment, replevin, mandamus, prohibition, and habeas corpus. Usually the analysis focuses on money damages, but you will encounter circumstances where these other legal remedies may come into play and will have to be analyzed in terms of whether there is a lack of an adequate remedy at law. The balancing of the hardships, the court will compare the hardship to the petitioner if injunctive relief is denied as compared to the hardship to be suffered by the respondent if an injunctive relief is granted. With regard to public policy, the court will examine whether the relevant public policies are implicated in granting or denying injunctive relief. With regard to the likelihood of success on the merits, to show the likelihood of success on the merits so as to support a request for a preliminary injunction or a TRO, a party does not have to meet the same burden of proof that is required at the final hearing on injunctive relief. Instead, the plaintiff, you simply have to raise the fair question as to the existence of the right which he or she claims and lead the court to believe that they will probably be entitled to the relief requested if the proof sustains the allegations made. So it's a different standard in terms of prevailing on the final argument on the merits for permanent injunctive relief as compared to requesting a TRO or a preliminary injunction. So let's assume that relief is granted. Pay very close attention to the language of the order. Make sure it is clear, specific, and capable of enforcement. Ambiguity, overbreadth, or impossibility of performance of compliance can be fatal to the efforts to enforce an injunctive order. One example that I'd like to share with you is a case that was actually been litigated at various levels in Illinois for a number of years, and an appellate decision was delivered on November 16th of last year on this. For those of you who have lived in Chicago for a while, I suspect many of you remember the E2 Nightclub disaster. Well, in that case, almost immediate, for those of you who don't, it's a nightclub that was roughly around 2200 South State of Michigan. A fight broke out in the nightclub, and people, while trying to rapidly exit the club, were trapped in a stairwell, and 21 or 22 people were trampled to death while trying to leave the nightclub. Well, as it turns out, the nightclub was under an order to have the second floor closed because of building code violations with the mezzanine level of the club. So the city brought a motion or petition for indirect criminal contempt against the owners of the nightclub because of their failure to honor the court order. The reasoning being, had they honored the court order, no one would have been in the club. The tragedy would not have happened. The problem with the building court orders in this case, however, is that there appears to be a great deal of dispute as to whether the order simply required that the mezzanine of the second floor actually be closed, or whether the entire second floor be closed. And you appear to have different explanations of this from the court transcript as compared to the court order, as compared to the court's half sheet. So you had no two of these three things saying the same thing in terms of what was actually required to have been done, whether the club was required to be closed altogether. So the defense in the case was that the orders were ambiguous, and therefore you cannot prove that there was a willful violation because my client really didn't know what exactly he was required to do. At trial, the defendants were convicted and sentenced to 2 years incarceration for criminal contempt. The case was appealed, and the appeal was overturned because of the ambiguities in the court orders. A great deal of evidence was presented at trial and then discussed further on appeal, pointing out that there are numerous letters back and forth, various court appearances at which parties gave competing representations of what they thought had been ordered, or there were apparent agreements as to what had been agreed to, when in fact the parties were just not on the same page as to whether the entire second floor was to be closed or just the mezzanine level, or whether the entire club was to be closed. It was also pointed out that the order had been drafted by one of the clerks for the City Corporation Council, that the respondent's lawyer left the courtroom before the order had actually been fully drafted and entered, and in the rush of practice, I'm sure many of you have seen, well, we know what the order is supposed to say. Just send me a copy of it later, or the order is hurriedly written out. If you are really expecting to depend on enforcing this order by the court's contempt power, really take the time to make sure that it says exactly what you need for it to say, because if you then come back to have it enforced by the court's contempt power, the ambiguity in the order may very well prevent or preclude contempt enforcement of the order, either by criminal contempt or civil contempt. And we'll go into a bit later about the different distinctions between civil contempt and criminal contempt. The other problem is, with an improperly worded order, are you directing a party to perform an act that they are simply not capable of performing, and it wasn't immediately clear from the language of the order that when the party who was bound actually tried to perform, they actually could not. These kinds of problems, they may not seem like a big deal when you're hurriedly writing out the order in a rushing to get to the next court proceeding. And a case like the E2 Nightclub disaster happens very rarely, but it does vividly point out the downfall or the hazard of not taking the care to write the order so that it provides the relief that you intended for it to provide. Now, as the truth of the matter is, the real harm at issue in the building code violations, they were not concerned about people possibly being trampled in a fight at the nightclub. The real problem was the fact that the mezzanine level had been constructed without proper permits, and one of the arguments raised both at trial and on appeal, and the judges did spend a lot of time weighing this consideration, was the reason that the tragedy happened was not a direct result of why the orders were entered in the first place. It's not as though the people died because of the lack of structural integrity of the mezzanine, and the mezzanine collapsed and landed on the people. Rather, you have simple but-for causation. If the people had not been there, the trampling would not have occurred, but it's not the purpose for which the order was entered was not relevant to the reason that the actual harm took place. And the appellate court did spend a great deal of time questioning whether it's appropriate to imprison someone for 2 years for violation of a building code order. According to the court, they could not find a single case where someone had actually been sent to prison for 2 years for violating a building code order. And while that was not one of the bases relied on in the decision, one gets the feeling, particularly if you listen to the oral argument, the court considered that it would appear that the court considered that sanction to be excessive in light of the purpose for which the order was entered and the nature of the violation at issue. So the contempt convictions were overturned. I simply printed up the version of the opinion that's available on the court website, but if you'd like, if anyone wants to send me an email, I'm happy to forward the full version of the opinion if you'd like to have it to review. The TRO and preliminary injunction, they are enforced by the court's contempt power. Civil contempt proceedings are initiated by a rule to show cause why the party who is alleged to have violated the order should not be held in contempt. There are a number of different ways in which the law of contempt is organized. One principal division in the law of contempt is between civil contempt and criminal contempt. Civil contempt aims to bring a party into compliance with a court order. Its purpose is not to punish. Criminal contempt, the purpose is to punish for a violation of a court order that has already taken place. It is possible to have both criminal and civil contempt proceedings taking place with regard to the same course of conduct. If the court believes that its dignity or authority has been affronted or violated by the conduct, it has an interest in vindicating its authority through a criminal contempt proceeding. But at the same time, if there is an ongoing or prospective interest in achieving compliance with the order, there would still then be reason and a proper basis for also seeking civil contempt as well. One often cited example of civil contempt is, for example, imagine a reporter who is given a grand jury subpoena, refuses to testify. When that reporter is then jailed for refusing to testify before the grand jury, that is a civil contempt sanction. The purpose of the sanction is not to punish the reporter for not testifying. The purpose of the sanction is to induce the reporter to testify, and immediately upon agreeing to testify, the reporter will be released. An example of a criminal contempt sanction, like we just discussed with the E2 Nightclub matter, when a party has committed an already completed violation of a court order and the purpose is to punish, you may have either significant monetary fines or significant jail time as the sanction for criminal contempt. For serious criminal contempt violations, meaning a violation which the possible punishment exceeds $500 or 6 months, the constitutional due process protections of right to a jury trial, right to counsel, and a right against self-incrimination do come into play, again, for a criminal contempt trial for a serious violation. Another issue that comes into play with the enforcement of a court order is the Collateral Bar Rule. Let's discuss what happens if your client is subject to an order that you are absolutely convinced is just wrong. Either there's been a horrendous miscarriage in terms of the court's finding of facts, or the court is absolutely wrong on the law. Can you advise your client to go ahead, violate the order, and then don't worry, we're going to appeal this and you'll later be vindicated on appeal? Under the Collateral Bar Rule, you cannot do that. Your client must continue to obey the court order while it remains in effect, even if it is subsequently determined that the order was erroneously entered. Even if the order embodies a statute or an ordinance that is later determined to be unconstitutional, if your client is charged with contempt of that order while it was still in effect, the fact that the order was later overturned on the grounds of unconstitutionality, that will not be a defense to the contempt proceeding. One of the most famous cases on the Collateral Bar Rule, Walker versus City of Birmingham, decided by the U.S. Supreme Court in 1967. It involved the civil rights protesters in Birmingham, Alabama, under the direction of Martin Luther King. They arranged for a protest in Birmingham beginning on or just before Good Friday and proceeding through Easter. And immediately before their protests were scheduled to begin, the city of Birmingham got an injunction, an ex parte injunction, which simply incorporated the language of an Birmingham city ordinance that prohibited ordinances conducted without a proper city permit. The protesters decided they were given the notice of the hearing, I believe, on Wednesday evening, with their first protest to take place on the following Friday morning. They violated the order, proceeded with their protest, and then immediately submitted themselves to the jurisdiction of the court to challenge the order. They were convicted of criminal contempt, and they appealed the matter to the U.S. Supreme Court. They argued that the underlying ordinance was flagrantly unconstitutional, and in a bitterly divided court, the court ruled that regardless of whatever infirmities with the order you simply have to continue to obey the order. Your recourse is to seek rehearing, seek an emergency appeal, and I do urge to my students that most courts, if not all, they do have a capacity for getting an emergency hearing heard by a night judge, but making the argument that I just didn't have time to bring an argument to seek rehearing or an appeal, that is an exceedingly difficult argument to make to justify violating a pending court order. Interestingly, the following year, after the criminal contempt convictions in Walker versus Birmingham were upheld, in 1968, in the case of Shuttlesworth versus Birmingham, the very ordinance that sustained the Walker convictions was found to be unconstitutional by substantially the same court membership that had upheld the criminal contempt convictions of the protesters. So the point of the collateral bar rules, if your client is subject to an order, no matter how erroneous you are convinced the order is, your client has to follow it. Your recourse is to seek rehearing or appeal. Absent that, your client is at risk of contempt of the court order. There are some narrow exceptions to the collateral bar rule, one being showing that the proceedings are essentially just a sham, that they're just flagrantly ill-motivated. As I'm sure you can imagine, that is an exceedingly difficult thing to convince a reviewing court of, that the court that entered this is simply conducting a sham proceeding or doing this merely for purposes of harassment. It is a recognized exception, and if you look at the opinion in Walker versus Birmingham, many of the dissenters come surprisingly close to actually accusing the lower courts of doing precisely that. One other important exception to the collateral bar rule is the case in which the trial court entered the order without jurisdiction. There's an important distinction to be made between an order in which the court simply got the facts wrong or got the law wrong, as compared to a case where the court purported to exercise jurisdiction that it simply did not have. In the latter case, the order entered without jurisdiction is a nullity, and the collateral bar rule does not apply in the case where the court acted without jurisdiction. There is obviously some risk in urging your client to proceed to violate the order on the grounds that I am confident that on review the appellate court is going to agree with us that this was undertaken without jurisdiction. There is one case, a federal case, that actually reaches that ruling, Donovan versus City of Dallas. I don't have the site in front of me, but that's a case in which there was a dispute over building additional airways for the Dallas airport, and the people who were challenging the construction of new runways, they filed one suit in state court, lost, then filed another suit in federal court. The people who were the City of Dallas, then got an injunction against the petitioners from continuing to litigate the matter in federal court, and the petitioners were then actually held in contempt for violating the injunction against litigating in federal court. And the Court of Appeals ruled that the state court simply did not have the jurisdiction to enjoin parties from litigating in federal court. And because they did not have the jurisdiction to do that, the collateral bar rule did not apply, and they vacated the criminal contempt convictions. Let's now discuss declaratory judgments. The law of declaratory judgments, they are addressed under Illinois law under 735, section 52701, and under federal law under Federal Rule 57. The purpose of the declaratory judgment, it allows the court to address a controversy earlier than it normally would once a dispute is developed, but before the parties have taken steps that might otherwise expose them to damages or other relief. One example, particularly in Illinois, where you will often see declaratory judgments resolved surrounding insurance disputes. Let's imagine an insurance carrier has decided that we do not have a coverage obligation, nor do we have an obligation to provide a defense. You often see a declaratory judgment filed with regard to the rights and responsibilities of the insurance company with regard to the insurance policy, rather than taking the risk of just declining coverage now and then down the road, if it's determined that, well, the insurance company actually did have an obligation to cover and defend, and because they failed to do so, they're now going to be subject to a lawsuit. So rather than take that risk by getting a declaratory judgment at the beginning of the proceedings, you get the court's determination as to whether the policy requires coverage and a defense or not. Declaratory judgments are also used with regard to declaring the rights and obligations of a wide variety of legal instruments or statutes to help parties determine what their rights and obligations are, so that rather than having to commit an act that would be viewed as a violation of those obligations, they can get guidance from the court without having to take that risk. One practical problem that comes into play that is addressed by the declaratory judgment is that if you bring a TRO or preliminary injunction to challenge the constitutionality or the propriety of a statute or an ordinance, a court may explore the question as to, is there any real likelihood that the petitioner is going to be charged with violating this? If the court concludes that it is not satisfied that there is a sufficiently real possibility of this person being charged, the court may conclude that we don't have a controversy here. Case dismissed. So the declaratory judgment affords an opportunity to get a review of a statute without the challenge of satisfying the court that I really am likely to be charged or indicted under this statute. I mean, the one way around the first problem in the absence of a declaratory judgment is just go ahead and violate the act, but then of course your client then subjects him or herself to actually being prosecuted. So you don't want your client to have to violate the law in order to create the standing necessary, or that may be necessary, to seek court review. The declaratory judgment action is a creation of statute. It is traditionally not considered either as an equitable action or a legal action. The elements to be pleaded for declaratory relief: one, that there is a tangible legal interest. You have to plead facts indicating that the defendant's conduct is opposed to those interests. And third, that an ongoing actual controversy between the parties is likely to be prevented or redressed by the court's action. In other words, you have to show the court, by declaring the rights and obligations with regard to the legal instrument at issue, a real controversy will be averted. If the court is not satisfied that anything is going to be resolved by issuing the declaratory judgment, then it's essentially, you'll be asking the court for what's effectively an advisory opinion. Declaratory judgments, they are not advisory opinions for these very reasons, so it's important to be sure to distinguish that you're not asking for an advisory opinion when you ask for a declaratory judgment, assuming, of course, that you can demonstrate the real controversy and demonstrate that the controversy is likely to be resolved by the court granting a declaratory judgment.
Jerry?
Yes?
Could one use a declaratory judgment knowing that one is about to be sued to choose a forum in which to claim that whatever rights someone was asserting against them are not valid? I know you're going to sue me. You've rattled your sword, you've said you're going to sue me, and you're going to take me over here to the circuit court. And it just happens we have diversity of citizenship for $75,000, and I take it to the federal court seeking a declaration that you don't have a valid cause of action against me. Is that something that would work in declaratory judgment?
if the court is properly, if you've properly demonstrated diversity of citizenship, if you've satisfied all the elements for the federal court to exercise jurisdiction, yes, there's always the race to the courthouse. One party wants to litigate perhaps in state court, the other party wants to litigate in federal court. You frequently will have that contest, but yes, parties may, if you can satisfy the elements for federal jurisdiction, yeah. Of course, it raises the question, if you know you're about to be sued, the other side, perhaps they should be moving a bit quicker than they are, but there is often that race to the courthouse, and sometimes you win, sometimes you lose. But yes, that is one appropriate thing to do. Why would a party seek a declaratory judgment instead of a preliminary injunction or a TRO? Well, in some cases, it may be easier to establish jurisdiction, particularly as I made reference to earlier, in challenging the constitutionality of a statute. You don't run into the same standing barrier with a declaratory judgment as you would with a preliminary injunction or a TRO. In other words, you don't have to show that I'm certain that I'm going to get indicted or prosecuted under this particular statute. And just to make the point that that's not a fanciful or preposterous position for a court to take, as I'm sure you're all aware, there are lots of statutes on the books, some of which are rarely or perhaps not at all enforced or just so ancient and just out of use. The court does not want to have its time tied up with people dragging out statutes under which no one has been indicted for 50 or 60 years to, well, there's a theoretical possibility that I could be indicted under this. The court really wants to devote its time to real controversies, not matters that are just theoretically conceivable but just almost certain to not happen. So courts will, on occasion, really press the issue, are you really likely to be indicted? I've heard of at least one case where a party got around this problem by actually writing his district attorney and asking, if my client is involved in these certain activities, there is this statute, would your office indict my client over this? And he said, yes, we actually would. And the state's attorney also wanted the clarification of a declaratory judgment. So there are some circumstances in which you actually may get cooperation from a prosecuting authority to satisfy the court that this is not just a fanciful or theoretical exercise. There really is an issue that needs to be resolved. There really is a controversy here. But the use of the declaratory judgment makes it exceedingly less necessary to go through those kinds of measures. Another benefit of seeking declaratory judgment rather than equitable relief, there is no need to show the irreparable harm. Also, there is no bond requirement with a declaratory judgment, and there's no balancing of the hardships. So when the court is evaluating declaratory judgment, the court doesn't get into, well, how much is one side going to be hurt as compared to the other. They're really looking to make what amounts to, at the end of the day, after its determination of the facts, make a legal determination. Also, the traditional equitable defenses really don't come into play. For example, if you're afraid that your client might be subject to a claim of unclean hands, that really shouldn't be coming into play with a declaratory judgment. So keep these equitable defenses in mind when evaluating which theory makes the most sense for your client in terms of how to proceed. Declaratory judgments, typically, they are not enforceable by the court's contempt power. The declaratory judgment is simply to declare what the rights and responsibilities of the respective parties are, but it typically will not affirmatively direct a party or prohibit a party from engaging in a specified course of conduct. So one case where this came up last year, actually in Wisconsin, the whole bit over the legislation with regard to eliminating collective bargaining rights of the unions. One party got a declaratory judgment stating that the statute was invalid because it was passed in violation of the open meetings law. The order, however, did not preclude or prohibit any officer of the state from taking any further measures to actually implement the law. So you had a declaratory judgment that said what the petitioner wanted to say, but others in Wisconsin who frankly just disagreed with that court and appealed it, they went on to proceed to try to enforce the law anyway. So if your controversy is one of the nature such that the mere declaration of rights will not in and of itself preserve the status quo or provide all the relief that you want, it may not be a complete or sufficient remedy for you. And as I began by mentioning, you will frequently see today petitions including a request for a TRO, a request for a preliminary injunction, a request for a declaratory judgment, and a complaint for permanent injunctive relief. So the request for the declaratory judgment, it has strategic benefits that you don't have with the others, but it may not provide for complete relief. So my conclusion is when you see all of them alleged together, you're not just seeing an example of overkill where the lawyer is simply just throwing every instrument at his or her disposal. There really are important strategic advantages to each of the pleadings. That concludes my prepared remarks, and I'm ready to take any questions you have. Yes?
The last thing, when somebody comes in with a document like you just identified, with all these various kinds of relief being sought, including a declaratory judgment, why wouldn't the judge just look at this and say, you need to file a normal, there's no point in me trying to expedite the entire trial or the hearing on all these issues, but you should stand in line with everybody else.
Well, remember, what the purpose of the TRO and the preliminary injunction, they are to preserve the status quo.
Right.
So the court will, to the extent it concludes that yes, there are exigent circumstances which really demand that we enter some sort of injunctive relief to preserve the status quo while the underlying controversy can be litigated. So, I mean, if you're looking for immediate relief, the declaratory judgment is not the proper instrument because the court's going to want to have a full hearing on the merits. They're going to want full briefing of the legal issues. And if your position to the court is that the sky is going to fall in 24 hours unless some relief is granted, the declaratory judgment is not the appropriate instrument for that. The TRO or the preliminary injunction can be to the extent that the court really is persuaded that you have sufficiently exigent circumstances so it will preserve the status quo, but then allow the parties to litigate fully on the merits in terms of whether to grant permanent injunctive relief. So I guess to sum up, the TRO and the preliminary injunction, they're aimed at getting immediate relief for the purpose of preserving the status quo. The other petitions, they are aimed at a more lengthy proceeding.
Okay.
Okay? Yes?
So in your example in Wisconsin, they didn't file for a TRO? Or they didn't?
I think they filed for a declaratory judgment. That's what was granted. Ultimately, the order was overturned, saying that they did not have the authority to enjoin legislation because of violations of the Open Meetings Act. But the original order that was rendered, it simply declared that the statute was passed in violation of the Open Meetings Act. It did not affirmatively enjoin parties from actually trying to implement the order. Moreover, the application of the declaratory judgment, even if it did purport to apply to specified state officers, if there are other state officers who still might be in a position to try to enforce or implement enforcement of the act, if they're not named in the order, the declaratory judgment will not provide relief. So that may seem like a minor technical distinction, but it turned out to be a fairly important one in Wisconsin, and it's an important one to keep in mind when you're considering what form of relief to request. A word about the application of the order. Well, typically a court order is enforceable against the parties who are actually who have actually appeared before the court. Courts do, under certain circumstances, have the inherent authority to make their orders more broadly applicable to the community at large. One example you will see of this, if you ever review Supreme Court cases on school desegregation decrees, where the court concludes that in order for it to preserve the status quo with regard to the underlying controversy regarding schools desegregation, it's not enough that the order simply be enforceable against the parties who were actually served and appeared before the court. They will actually make the order broadly enforceable against the community at large, because their concern is that people who are very much engaged in the controversy but who are not formally named as parties, they may take actions in their own hands that might take sort of purpose of undermining the court's ability to continue to adjudicate the underlying controversy. So under those limited circumstances, courts may make their orders more broadly applicable beyond the parties who were actually named and present in the court proceedings. Declaratory judgments.
Does it have to be applied that way?
Hmm?
Does it have to be applied that way?
In the case, if you seek to have the court's authority exercised that way, I would certainly plead it that way. I wouldn't. It's in the case that most vividly describes this as the United States versus Hall, again involving school desegregation. That issue was not initially pled. The court concluded that on review, on appellate review. I think that if you want the court's enforcement to be as broad on that basis, I think you should plead it that way, so that you're not after the fact coming back to the court saying, well, clearly these are circumstances that dictate that the court's order be broadly enforced. I mean, it obviously invites the question, well, counsel, if you really believe that, why didn't you argue that earlier? I mean, it's entirely possible that the circumstances that were present at the initial pleading may not have led the petitioner to think that it might be necessary to do that, but then you can always go into the court and seek to amend the order to clarify the issue as to how broadly the order should be enforced. Any other questions?
Anybody else? Okay,
I think we were at the 1 hour mark.
I think we are. I think we hit it on the dot.
Well, thank you very much.
I'm going to place these CLE certification forms over by the door here, as well as the evaluation forms. If I can get through here.
No, man.
Thank you, that was very well done.
Oh, thank you. Well, thanks, man.
Very good.